Episode of Bobby's Business Club, the chat show live. Bobby's Business Club is an online networking community of business owners from around the world. And I say around the world because we have members in Singapore. We have Karen White, who is from Singapore as our co-host today. We also have members across Australia and the Philippines and in China and the UK as well. We meet every fortnight for 1 hour, and Bobby's Business Club is all about saving time for you. We allow you to come and connect with our members and guests, and then the idea is for you to go and make the magic happen in one-to-ones. Part of our process, what we do is we don't have time to do a presentation normally in our 1 hour meetings. And so what we do is we bring our members and guests into our live chat show arena where we are now, and they can present about their business in a more relaxed environment rather than being stressed and trying to squeeze in a presentation in 10 minutes. They can get up to half an hour, 45 minutes, as long as they like. And the beauty of it, we record it, we do it live and we record it for our members. And this goes onto our LinkedIn profile, our Facebook profile as well, where we have over 10,000 followers. It also gets recorded, so our guests and members can take it away and use it in their social media. And today we have our wonderful guest today who's going to be talking about play it safe and get your legals right with Glenda Dennler. And the subject is if you set up the right business structure and spend time getting your contracts right, you can greatly minimize your business risks. And so Glenda is from Top Notch Legal, and she's going to be telling us all about that now. Glenda, if you want to do a bit of intro about yourself and then go into your presentation, you can take it away whenever you're ready.
Thank you, Bobby. So as Bobby said, my name is Glenda Dennler, and I've been a commercial lawyer for over 30 years. So I've been through a lot of changes in the law and worked in many different industries. So Top Notch Legal, we are lawyers for business. As I say, this means we don't deal in property. We do, except for commercial leases, of course, and we don't handle divorces, and we don't do criminal law. We look after businesses and business transactions. And what we want to do is we want to take you from the screen, from the picture on the left to the one on the right. So from stress to being relaxed, knowing that you've got all the legal loopholes covered. And if you're sued, they can't take you to the cleaners. Now, today I'm going to focus on three main areas. I'm going to talk about business legal structures, the types of contracts we do, and business relationships. Now, I'm going to try and make it interesting, but it is the law after all. So we have a few limitations here. All right, now looking at business structures. So there are just a few main legal structures that are used for small to medium-sized businesses, and they are sole trader, partnership, company, or a trust structure. Now, if new business owners are starting up and there's not a lot of capital involved, then I usually suggest they have a partnership agreement, unless, of course, they're a sole trader. But if the business has been going successfully for a while, or an owner wants to purchase an ongoing business, then a company or a trust structure should be considered. Now, recently, a client asked me to advise them as they are setting up a new training division. So this client's business is as a vendor and buyer's advocate. They're looking to grow the number of consultants that they use, and they want to set up a separate training academy. Now, at the moment, the business is operated under a family trust, discretionary trust structure, and they have a company as the trustee. The question here for the client was, should this training academy be set up as an entirely separate entity, or should it be set up as a division of the existing business? Now, there are different tax implications that need to be considered. Also, setting up as an entirely separate entity is much more expensive, but it does mean that it's easy to sell off if the business is successful. It also means that it's very easy to keep control of intellectual property. But as I said, the cost of setting that up is more expensive, and then you have these ongoing annual fees to ASIC. So these are the sorts of things that we have to look into when we're advising you about what structure to use. Now, next thing I want to talk about are contracts. So as you can see from the screen here, we talk about contracts, and more contracts, because that's most of what we as commercial lawyers deal with. And there are all sorts of different contracts. Could be an employment contract, could be a confidentiality agreement, as you can see on the screen. It could deal with anything. But the main thing I do is that I prepare, negotiate, and amend contracts. And So I'm going to talk about one of my clients. Now, when I talk about a client, in most cases, I'm changing the name. In some cases, I'm changing the industry because for confidentiality's sake. But in this case, they are a large plumbing contractor, and there are three owners in the business, and they need all sorts of contracts. But this example can work for most industries. It could be, you could have service delivery, you could be selling products, or it could be a manufacturing division, a business. Now, sometimes this plumbing business, they work directly with the owner of the site. And so in that case, they're expected to supply the contract, in which case I get involved and I write the contract up for them. And a contract for supply covers all sorts of issues, which is about the standard of work, what they actually have to supply, the breakdown of the costs. That usually they're paid in stages, when an invoice will be delivered, how many days before the client is liable to pay. They're all the sorts of things that get covered off, including liability. Now, at other times, my clients tender for very large jobs, and you can see here, we're talking these sorts of jobs here, and you can imagine the large developers that are behind a complex like this. Now, the developer in this case will present their standard contract, and of course, you can imagine they're really big, thick contracts, and they take a lot of work, but I get to review those contracts. Now, at other times with this plumbing contractor, they need to hire staff. Sometimes they'll be employees, at other times they'll be subcontractors, and you require quite different things for a subcontractor versus an employee. It's very important to get that right. Otherwise, you could find yourself being penalized. So another thing I want to point out is that when you're dealing with big business, for example, the slide I gave you a few back with a very large development, the owners or the developing companies of those sorts of complexes, they have very large standard contracts, which they often will present to the smaller business. So in my case, although my client is a large plumbing contractor, they're nothing like the size of that particular developer. And so they'll be faced with going through that particular contract. Now, what often happens, you get large business and small business, and the large business has their standard contracts. And in the past, what's happened is the large business goes to the smaller one and says, here you are, take it or leave it. If you don't sign on the dot, we'll go somewhere else. And so the smaller businesses have been afraid to lose the business with this large company, and so they've just signed on the dotted line. And in many cases, there are what's known as unfair clauses in those contracts. In most cases, an unfair clause is where it's highly weighted in favour of the large business and certainly works against the smaller business. But in Australia now, we have special legislation, which is known as the unfair contracts regime, that protects smaller businesses in these situations. And so smaller businesses should negotiate these deals with large businesses, and I get a lot of satisfaction in helping them negotiate these. And I'm going to give you just one example of the sorts of things that we're talking about. So it's common, as I said, for big businesses to give themselves an out in the contract. In other words, they can end the contract at any time they like. And let's say you have a contract and it's for 3 years. And it can be disastrous for the smaller business if the large business pulls out, say, within 6 months, 9 months. The smaller business hasn't really got their money back on that contract. Now, if they're in the business of, let's say, information technology managed services, and the smaller business, IT business, signs up this very large contract with a large business, they'll have to buy in a certain amount of equipment, they'll have to take on extra staff in order to service that contract. So usually that means they're off to the bank to ask the bank for a loan. Now, they'll price this on the basis that the contract's going to last for 3 years and we'll get all our money back in, say, 2.5 years. And after that, we're really into the profit line. But what happens if then the large business has got the right and just pulls out 6 months later, it doesn't suit them, so off they go and they say, oh no, we're finished. Then the small business is in trouble. So these are the sorts of clauses we call unfair clauses, and it's really important to negotiate them. Now, going back to, oh, sorry, I've just pushed that the wrong way. Here we are. So going back to my client that is running the plumbing business, let's say they have both a commercial division and a domestic division, and they decide that they're going to sell off the domestic division. So they're going to need a contract for sale to sell off that particular division. And a contract of sale or a contract to purchase a business is usually quite complex. There are so many things that need to be considered. And so you just take this type of example. Some of the things we'll be looking at is what equipment is going to be sold. Will it all be sold, or just some of it will be sold? Is the equipment already owned by the selling business, or is it under some sort of financing arrangement? Some of the equipment might already be owned outright, some may not be. Will the buyer of the business take over the staff? And if so, which staff? And what entitlements are the staff have logged up that need to be transferred across? What intellectual property does the selling business own? Are there logos? Are there trademarks? Do they have a business name? They all have to be looked at, and there are different legal considerations for transferring those across. Are there important contracts with customers? This is a big one. So if you're looking to sell a business at any point in time, it's very important that you have good, solid contracts in place with your customers, because at the end of the day, that's the value of your business. And so on and so on. It depends on the nature of the business, all the different things that we have to look at, but they're just a few of the regular things that need to be considered when you're buying or selling a business. Next thing I want to do is talk about business relationships. Okay, so the relationships amongst business partners is crucial to any business. And when I say partners, I'm referring to all the owners in a business, whether it's a company or a trust or even just a partnership. And in this example, I'm using the example here of software developers. These were clients of mine, and they didn't come and see me when they set this business up. They came to see me when they were in trouble. So this is how the story unfolded. So in this case, they had failed to put proper agreements in place. And my client, Peter, started a software development business, and Nick joined him as a partner later on. At the beginning, they shared everything 50-50. And for about 3.5 years, they built the business up very successfully. But then there was a drop-off in business, which Peter felt was largely due to Nick's incompetence. Nick's work had become sloppy. His turnaround time was slow. He didn't keep his promises to the clients, and there were mistakes. Peter felt he was doing the bulk of the work and resented Nick being paid 50% of the money that they made. Peter then found out that Nick had registered a business name very similar to the one they used for their joint business. He believed that Nick intended to go out on his own and most likely steal their clients. Now, they had some discussions about dissolving the partnership. At first, Nick indicated he was happy for Peter to take the major clients, but later Nick changed his mind once he realized that what he was left with wouldn't generate much income. And they also argued over who should take what pieces of office furniture and equipment. Plus, there were premises that they leased, so they had to decide who would take on the lease. Now, if they'd had a partnership agreement, it would have provided a mechanism for either of them to depart the business. It would have regulated how they divided up all the assets, and most importantly, would have prevented one of them setting up on his own and taking the clients. They negotiated a settlement which took several stressful months to achieve and was expensive, at least double what it could have been if they had made an agreement in the first place. So that's that example, and we've got one more to show you. So in this case, I'll call them the trainers. And this is an example about a situation where the business partners did put documentation in place, and it was just unfortunate that it didn't go far enough. This situation involved one of my clients, but I've changed the names, as I've said, and I've changed the industry. The example might not be totally applicable, but you'll get the idea. So Jake and Josie were both ex-lawyers who became highly professional in training lawyers in Australia. They met because they were frequently the key speakers for all-day events at conferences, and they began to see that there was a gap in the marketplace they felt that they could fill together. And essentially, it was to build an online platform that supported the training they gave at conferences. Let's say they had given a talk on the latest strategies in hiring and firing staff in Australia and New Zealand. People would be able to go onto this platform, ask a legal question about this topic, and the platform would provide the answer after referring to legislation and the latest court cases. They both had a sound knowledge of the law, and Josie particularly in employment law. On the other hand, Jake had top computer skills and the ability to build their platform from scratch. They invested money in setting up a legal structure before they began, and they continued to do their regular work whilst they put the new business together. Jake focused on building the platform whilst Josie set up all the possible scenarios that the lawyers were likely to ask the system once it was up and running. Now, a year later, they were almost ready to launch the program. And Jake, whilst he was speaking at a conference in New Zealand, told the audience about this new product they would be offering and handed out a feedback form to see what the level of interest was. The majority was thrilled with the idea and said they'd be very interested in purchasing it. However, the day after he arrived back in Australia, there was an email from Josie landing a bombshell on his desk. She said she felt she was contributing far more than him to the business, and therefore she should be paid 70% of the money that the business made. Jake was floored. He spent hours and hours, nights and weekends developing the platform. How on earth did she feel entitled to say this? He came to see me because Josie refused to even discuss the situation. I suggested the quickest and cheapest way to resolve the issues would be via mediation. There would even be the possibility of repairing the relationship and maybe getting things back on track. But Josie wouldn't even consider mediation, and it was unfortunate that there was no document regulating how a dispute should be resolved. They should have had a unit holders agreement. Such an agreement regulates how the trust is to be terminated, so it's clear what each party has to do, when they have to do it, what they're entitled to, and how the business or the assets will be valued. But they were forced to negotiate. It took months to get them to a point where they could agree. And as with the previous example, it was stressful and expensive. So even if there's a company or trust, the business partners should still have a shareholders or unit holders agreement. And this will help not only if there's a dispute, but if one party wants to leave, there's a process and method of valuing the business, so further disagreement and stress is minimized. It also means that there should be a fair outcome for each of the parties. So that, I hope, gives you a good outline of the sorts of services that we provide. There are more services that we provide, but for a presentation of this nature, I don't want to confuse you too much, and I hope that gives you a good feel for Top Notch Legal, and thank you for listening.
Thank you so much, Glenda. And it's just such a minefield, isn't it? That you just never know, you don't know what you don't know. And this is why we need to use experts like yourself. Because we can come to you with the scenario or the situation that we're in. But it's like anything in this world, if we do it very early on, we can normally stop all the issues going by. But if we don't do it early on and we wait couple of years, all these issues build up, and then we come to you with the issue. And that's normally more expensive to fix. Would you agree?
Oh, absolutely. I mean, I often say, you just imagine you've got a bucket and it's got holes in it. My job is to plug up all those holes, fix up that leaky bucket so that you're not exposed. If you are exposed to any liability, it's minimized and you can manage it. And even an insurance claim will be a minimal insurance claim. If you have a large insurance claim, it's going to affect your premiums forevermore. And sometimes what will happen is if you've had a big insurance claim, certain insurance companies may even refuse to insure you in the future. So it's really important to have good legal foundations in place.
Yeah, very interesting. I have a question for you around the confidentiality agreement. Is that specifically for other businesses that you might be working for, or does that also go into the employee side of things as well?
Okay, so normally when you're doing a let's take a supply contract. So you've got a business, you may be supplying services or you may be supplying products. There should be confidentiality clauses in that contract. The same with employees. There should be obligations, keep confidentiality in the employment contracts. But where a confidentiality agreement is really important is if you're thinking about entering into a new business deal, before you start those negotiations, you should sign up a confidentiality agreement, because to make those discussions fruitful, you're going to have to share some confidential information about your business. And if you don't protect it under a confidentiality agreement, the other person can take that information away and use it to their benefit and to your disadvantage.
Interesting. And so if you could give us 3 top tips, me and Karen are going to go into business together. We've got this wonderful idea, we're friends. What are the 3 things that you would say?
We're talking from a legal perspective. Number one is I'm going to look at how much money you're going to be investing to start up with, to look at what structure is going to be most suitable for you. As I mentioned before, we can put you straight into companies and trusts, but they're more expensive to set up. And if a business doesn't have a track record, if there's minimal expense or capital being put into the business at that point, I'd probably just suggest a partnership agreement to get you started. Then we're going to look at the nature of the business and what are the exposures. And so usually I ask the client, where do you see you're exposed? Where do you see things could go wrong? Because they're the holes in the bucket that we want to seal up. And so usually it's very important, whoever you're supplying to, that we have a contract, we give you a standard contract that will protect your business when you're supplying your goods and services. And then we'll look at things like to make sure that you get the ABNs correct, your business names correct. So people get very confused. I often see them when they're entering into contracts, one business to another, they will describe the other entity quite incorrectly. They think it's sufficient to put on there just a business name and what we call an Australian business number. That does not work. You've got to get, so I'll have a little bit of education with them as well to make sure they understand some of these basics. And then if there's going to be employees, of course, we've got to put the right contracts in place. But usually with a lot of startup businesses, they'll take on casual staff or they'll take on contractors. And so we need to get that done correctly.
That's some great tips. Karen, do you have any questions?
Yeah, I had one. I'm really curious. So I am based in Singapore, but I have got obviously colleagues that are coaches as well. And one of the things that we were told, and I know a number of coaching schools do say this, is that you need to have a contract between yourself and your client. But I also know there's a lot of people out there that say that's not necessary. So what are your thoughts around that? When coaches particularly, that's probably more my interest is, or people in service type industries that are maybe not regulated by a certain sort of thing saying you must have this in place. What are your thoughts around that? Because it's really interesting to understand. I would think there is a liability there. You are offering your services. They are paying you for services. I use it particularly to contract from the beginning, so everyone's on the same page and very clear about what that partnership is and what I'm delivering and what they're expecting. But I'm wondering around that coaching space, because there are a lot of coaches from different schools, different certifications, accreditations, etc. out there. What are the legal requirements, or what would you recommend from your perspective that should be in place between a client and a coach?
So there's no real, with most types of coaching, there's no real legal requirement as such. But I mean, I've acted for coaches before, and my preference is that we give them a fairly friendly looking letter of engagement, because one thing that's really important with what you do in coaching is to set the expectations correctly. And so, and to exclude all the different things, you're not guaranteeing them anything. You cannot guarantee an outcome with coaching, but sorry, I just had an interruption there. You can't guarantee that. So this is what we need to set out very clearly in the letter of engagement. And at the stage, I don't think it doesn't need to be a tome of 20 pages and fine print, not at all. But we just need to cover off those basic things, I think is sufficient.
Yeah. Okay, great. Thank you.
It's a great answer, because I have a contract. I've got a few businesses. I've got a contract with all of them, and the recruitment bit, the business is my main business. But it makes it so much easier for me to go, this is what it is. This is what you're going to get. Like I say, there's no guarantee, because we can't guarantee anything. But sometimes people can look at it and go, whoa, that's like way too much information, even though it's needed. And to have that like a letter of agreement or whatever it is, something basic to outline, what's going to happen. We're going to meet every Friday, whatever. So, it just brings accountability, doesn't it, to it as well? So
yes, and I think a big issue with coaching also is that people make appointments with you and they'll cancel. You need to have some parameters around that. I think that's a big issue. You need to have some parameters around that. And, in terms of contracts, if you can put pretty much anything you want into a contract, both parties agree and both parties sign that, the courts will enforce that. Yeah. And so you're fully entitled to, say, well, if you don't give me 24 hours or 12 hours notice, then I'm going to charge you X dollars. If they sign that, that's enforceable.
Yeah, I've definitely got like that cancellation or refund policy around things when people pay in advance. I think it's really clear, like you were saying, you can call it what you want, but it's having those very much on paper. It's stuff to discuss before you actually get into the relationship. Because what I heard a lot through your presentation was, I'm not sure if they were lawyers specifically in your last example that I know you changed some things, but we think we know everything, but I think it sounds like just talking to someone that actually is an expert in that particular field, just to mitigate potentially what can go wrong, because I think everyone goes in with good intentions from the beginning. But as you go through and you start seeing the amount of work involved, like you sort of shared with your example, human nature comes in and you start to feel it's unfair. You start to feel a bit burnt out, all that kind of thing. And I think just putting it in from the beginning and just talking, having a conversation, I think is the first sort of step I would say in anything, because you're starting something that was just new, which is different to what you normally do. You're not necessarily the expert. Talk to somebody about it, like yourself. Find out what you need to know and then make a decision a bit more informed, I feel. Because I definitely heard throughout your whole presentation,
Yes.
it's like this could have been avoided.
Yes, that's right. It made it a lot simpler. It's so easy, when you go into business, it's like a marriage. You're so excited. You're almost in love. You can't imagine anything going wrong. Exactly. But I've seen it so much. And I think one of the biggest issues I've seen is that let's take a couple of men, say in their 30s, and they go into business. They've been mates maybe all their life. But now we're 40, we're both married, we've both got kids. There's a lot of other influences that are coming into their lives now, and they change. And it changes the dynamics in their relationship very often. So these contracts should be put in place very close to the beginning. So when if and when it does happen, and it does happen quite a lot, that things go wrong, we've got the process in place. And a big issue is how to value the business.
I can imagine. That would different, because I think it was definitely one. We had a presentation, didn't we, Bobby, maybe 2-3 months back, when they talked about exit strategy.
Yeah, that's right. Yeah.
And I think that's a big part of it, because sometimes like you were saying, it's like all fun and it's exciting. You start it off, but you have to think, what is my exit plan for this particular business?
That's right.
And then have that conversation. And it's not saying it's going to happen exactly the way that you think it's going to happen, but to have that conversation, it sounds like it's a really important, critical part, because I think things like lawyers and that, people think, it's nice to have, but I'll be all right for a little bit, and then a year or so passes, and like you said, circumstances change.
Yes, I think also that people sometimes get freaked out because they think lawyers are so expensive. Most of us smaller lawyers are affordable. I think they should be willing to check out first what it's likely to cost, and we can't always give a fixed price, because everything we do is tailor-made for that particular situation, but usually we can give a pretty good estimate of what it's going to cost. And so there are horses for courses. So if you've got a big business, you go to the big legal firms. If you're smaller, you go to people like Top Notch Legal, who are smaller, who have fewer overheads and are more affordable.
That's right.
And so do you work, you mentioned, I'm not sure if that was true or not, the Australia and New Zealand. So do you work across Australia and New Zealand?
Yes, yes, I do. Yes, yes. So I have practiced and lived in Australia for many years. I'm currently just residing in New Zealand. And so, and
Kiwi here.
So, and the law, when we're talking about commercial law, the laws in Australia and New Zealand are very similar.
Yeah. But we won't say anything about anything else. We've got the Rugby World Cup coming up soon, so.
Yeah. I have another question for you, and apparently you accidentally saved someone or a client from being sued. How did you accidentally save somebody from being sued?
Okay, so it was sort of accident, but not in a sense. So one of the things I always do in a contract when I'm asked to prepare a contract for a client is that we have clauses in there that limit their exposure to liability. And so you're not allowed to completely wipe out liability in Australia. For example, if you have a contract that says, okay, I'm going to supply you with X, Y, and Z, but if anything goes wrong, I'm not going to have any liability whatsoever. Well, the Australian courts look at that and they say, well, what's the point of having a contract? If you're not going to be liable for anything, contract's pointless. So they will just get a line and completely rule that out. And so if you've got clauses like that in your contract, I'm sorry, but it's going to be worthless. And so what the effect of that is, you've got no restriction on how much you can be sued for. You're completely exposed. So in this particular case, we had drastically limited the liability of this particular client. And they wanted to be an internet service provider and had entered into negotiations with a large company that could provide them with the state-of-the-art platform that they needed. And they got all excited. There were, because it's an internet service provider, there were lots of contracts that had to be negotiated and signed off. And so what happened was they got started, and the platform had to be it was just the basic platform. It had to be modified and built to meet my client's expectation. And 3, they had weekly meetings, and they would set targets at those weekly meetings. And every week when they came back, the targets from the previous week were not met. But after 3 months, my client came to the conclusion that they were never, ever going to be able to deliver the platform in the way that they presented that they were going to. And that the information that was available from what they had built was pretty useless. It was so basic, you could do that writing things out on bits of paper. And that was just meant that the business was just not going to be financially viable at all. The problem was that, you'd think, well, my client should be able to sue them because they didn't deliver what they said they would deliver. The problem here was that the technical specifications in a contract of that nature should be very detailed. I'm a lawyer, I'm not a technician. And the technical specs were totally inadequate in the contract documentation, sad to say. And so the argument was, well, yes, they had delivered a platform, even though it didn't meet what they'd represented it was going to do. They had delivered a platform, so my client couldn't sue them. Now, what happens if my client terminates the contract? They could be sued. They've got a contract. They're paying all this. They're paying large sums of money every month while this platform's being developed, and it's hurting. And they want to stop it. They want to cut their losses now. So if they cut, under any normal contract, you cut that contract off, now you're exposed to liability because you've breached that contract by terminating it. But because their liability was reduced to a very small amount, they just terminated and walked away. And so they were not sued. So, and maybe in another time, I will talk about some new developments in the law in Australia. Australia has been very slow to adopt the concept of good faith in contracts, and it's creeping into contracts now. It needs to be clearly defined what it means. But if we had had that back then when this contract was negotiated, I believe it could well have saved the day.
Interesting.
So that's something I've started to talk quite a lot about.
What is the definition of good faith? Like, is there a short definition, or is it?
Well, it needs to be written into each contract, but essentially it means some of the elements that have been identified are that you will achieve the purposes of the contract. In this case, the purpose was not achieved. That you will not do anything to harm the other party. Things of that nature. So they're kind of vague, but they set out, it's like you've got to have this attitude when you go into the contract that I'm here to achieve the purpose of the contract. No matter the fine print, you've got to achieve the purpose.
So to act in good faith, like you come in with the intention.
That's right. And there are some other elements, I can't remember them just off the top of my head, but there's some other elements that have been identified as what should be in good faith, but you've got to put them in the contract. You can't just say parties will act in good faith. What is that? So again, you've got to get a lawyer to write that into the contract.
Yeah, no, that's very interesting. So I mean, take me for example. If I'm a coach starting my business either New Zealand or Australia, and I want some legal advice, like you mentioned, I would instantly think, oh my gosh, that's going to cost me so much money. I don't want you to give me a price, obviously. Is it able to have a conversation from the start with you? Is that sort of something that comes with a cost, or is it like have a conversation and then you go through that process where you're able to then go, this is what I estimate the cost will be, and then you can have an, is it like that? Is that how it kind of works with Top Notch Legal, that a person is able to approach you, or is there actually an investment from the beginning?
No. So in many cases, a client, well, for example, I had a client called me just a couple of weeks back and said, oh, I'm looking at buying this business. He already had been delivered a contract. So I said, well, send it across, I'll have a look at it. And then we'll have a talk. I don't charge for that. I'll have an initial look. It's the same, and you're saying, well, I'm thinking of selling my business. I'm going to need some sort of contract. Yes, we have a conversation about it. We need to explore what's really going to be involved. You might need to go away and do some things before you might think you want to sell it now, but maybe your business isn't quite ready for one reason or another to sell right now. And you might need to put a few things in place. So it's very important to have that conversation. To find out what you want to achieve with that, where your business is at, and I never charge for things like that.
Yeah, no, that's really helpful, I think, to know, because I think it's always that thought that initial you're going to have to make an investment before you actually have it. But it's great to know, like, you want to make sure that you actually want to work with this person too, I imagine, and that you can actually help them as well. Exactly.
Yes. And it's one of the fall downs talking about that to estimate, suss out that you actually want to work with the business. Because some years ago, I put my name forward for a some sort of legal platform where people could go onto this platform and pick out a lawyer that they wanted and get a fixed quote, but there was no relationship built. And I actually pulled myself off the site because I need to build a relationship. If I'm working with people, I want to have a relationship with them. I want to know what they want to achieve, who they are. You know, I'm a human being. They are human beings. It's not just about the bottom line.
Yeah, no, that's really important.
Yeah, I love that. And I think that's a great place for us to stop. And so, guys, if you're watching this live or you're watching, this is the recording. If you'd like to contact Glenda, what's the best way for people to reach you?
Oh, see the number there on the screen. That's a good way.
There you go, the number on the screen.
That's New Zealand, right?
Yeah, but you dial that from Australia.
Yeah.
Yeah, that number from Australia.
Yes.
Yeah. And you just go into topnotchlegal.com.au.
I know you're on LinkedIn as well. Can people find you on LinkedIn?
Yes, they can.
Yep. Excellent. Cool. And also you can reach out to myself or Karen and we can make that connection for you if you wanted to have an introduction to Glenda. And I'm going to pass it over to Karen. Karen, do you want to finish off and tell us a bit about yourself and then we can say goodbye?
Yeah, thanks, Bobby. No, I've really enjoyed today, Glenda. Thank you. I mean, I've definitely learned something, and I think it's just, I think it's that confidence in you going, yeah, okay. I remember bits and part of this in my corporate jobs and that, but I think just really, really interesting to understand that. I think as we have future plans ourselves about that kind of stuff, and also thinking about Australia and New Zealand. So it's really good to have that ability to be able to reach out to people like yourself. And it makes so much sense. I know it seems silly, but when you say, you know, you're a small business, reach out to a small business, like, you know, small business lawyers that are experts in that area. Really simple. So thank you. Yeah, just a quick little bit on myself. My name is Karen White. I'm based in Singapore, but I'm very happy to hear that Glenda's living in New Zealand. So I'm originally from New Zealand. It's very exciting. I help women over 35 to rediscover their passion and purpose, effectively moving from the chaos. And when I saw those pictures that Glenda had in her presentation, was like going from chaos to the sense of calm. And I think that's what we all have trying to do within our service, is just to remove some of that from people's lives and to really support them through that journey. So that's a bit about what I do. I really enjoyed today's conversation. Thank you, Bobby, for inviting me. And thank you, Glenda, for your time.
Thank you for the opportunity. I really appreciate it.
Thank you both for your time. Glenda, Karen, please stay on when I finish the call. And guys, if you are watching this and you'd like to come along and meet some other members and guests of Bobby's Business Club, you can reach out to me and I can arrange that to happen. Thank you for watching. If you're watching the recording, thank you so much, and we'll see you again soon.